In a criminal case, after a fully litigated suppression hearing, which the people lose, are the people allowed to make a motion to renew and re-argue with a brand new legal theory and have the judge reverse himself? To find out, you have to read People versus Lawson, but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Lawson. The citation for this case is 2024 New York Slip Opinion 06238, published by the New York Court of Appeals on December 12th of 2024. The issue in this case is whether a court commits error, whether it's error for a suppression court judge after handing down a decision suppressing evidence to reverse itself, to change its decision after getting a motion to renew and re-argue that has a different legal theory than the one presented at the suppression hearing. To understand and appreciate the context of this case, the background that's helpful to know is that in criminal law, evidence is subject to suppression if it's the result of police unconstitutional conduct. As a result of the exclusionary rule, if the police engaged in illegal conduct resulting in the acquisition of evidence, then that evidence can be suppressed for the purpose of a trial. And to do that, the defendant moves to suppress, and there's a hearing. And at the suppression hearing, the people, the prosecution, has the burden of proof to establish the legality of the police's conduct. The other thing you have to know is that there are principles of finality in New York decisions where basically, if the people have had a full and fair opportunity to litigate an issue, to oppose suppression, and the suppression court has issued a ruling on the merits, then if A and B, then the people may not have an additional opportunity to shore up their evidentiary deficiencies or legal position. That's basically just the general principles of legal finality. And the last thing you have to know is that under CPLR, under the Civil Practice Law and Rules, a party in New York can make a motion to renew and re-argue, and a motion to re-argue should be based upon matters of law or fact that the court allegedly overlooked or misapprehended, but cannot include new matters of fact not considered in the prior motion. Okay? So that's the background. What happened in this case? The facts are that in 2017, the defendant in this case allegedly made 2 U-turns in Manhattan, in New York City, and was observed doing that, was pulled over by the police officer and stopped. When the police officer approached the defendant's vehicle to ask for license and registration, the defendant allegedly gave a false ID, but also the officer made observations with signs that indicated that the defendant was intoxicated. So he charged the defendant with driving while intoxicated. The defendant then moved to suppress all the evidence and the observations and the fake ID, because on the basis that the stop was illegal, that the U-turn that he committed, that he did not commit any vehicle and traffic violations, that the officer didn't see him do anything that required them to pull him over, and therefore it was an unconstitutional stop, and therefore the evidence is suppressed pursuant to the exclusionary rule. So the defendant gets this hearing, and at the suppression hearing, the officer testifies the prosecution calls the officer, who says the defendant made the illegal U-turns. And on cross-examination, when the defense counsel said, well, what's illegal about the U-turns? The officer said, well, I just know they're illegal. And he says, well, what law did it break? He said, well, the vehicle and traffic laws. He was not able to identify the particular law violated allegedly by the defendant's driving. The judge then says, well, what about the business district rule? You can't make U-turns by a business district. Well, at that point, the prosecution tried to argue that this was a business district, but offered no evidence to show it was a business district. And at that point, the prosecution closed their case, ended their case. The judge then, at that point, the suppression court judge said, well, you haven't given me enough evidence to suppress. You haven't given me enough evidence to show it was legal. And therefore, I'm suppressing the evidence. You have not demonstrated the legality of the police conduct, and it's therefore illegal conduct. I'm suppressing the evidence. At that point, the prosecution then said, well, judge, we want to call another witness to show it's a business district. And the judge said, no, I'm done. The hearing's over. I'm denying that application. You're asking to reopen the hearing. I'm denying that application. A month later, the people file a motion to renew and re-argue, showing new rules, a new theory, basically saying that it's illegal to make a U-turn where there's a divided highway, which was not the argument ever advanced at the hearing. The judge reviews this motion to renew and re-argue, says, well, they're not offering new facts. The facts are already in evidence, and grants the motion and reverses himself denying suppression. The defendant now has this open case and pleads guilty to the DWI and gets 40 days jail. The defendant then appealed. And the appellate division affirmed the judgment, said the court has the inherent authority to correct its own errors, and that's what it did here. The defendant then appeals to the Court of Appeals, and they reverse. They reverse the appellate division and the trial judge and the suppression judge. Why? They say it appears the people were just unprepared at the hearing. They did not offer sufficient evidence to establish that the police were engaged in legal conduct. They didn't have the goods at the hearing, and the people had the burden of proof at the hearing. So because the people failed at the hearing to establish that defendant's U-turn was illegal, and that was their theory at the hearing, the people are not allowed afterwards to come up with a brand new theory of suppression and advance that in a motion to renew and re-argue. They say, of course, a judge has the inherent authority to correct its own errors. But in this particular case, because the new theory was advanced in the motion to renew and re-argue, that is not allowed, and this would be an abuse of discretion by the court. This is error by the court to allow this. And they also make this point in the oral argument, because this was not the theory advanced at the hearing, the defense counsel never had a chance to cross-examine about the median or the divided highway. So in a decision by all the judges, they say this was error. The order is reversed. The accusatory instrument is dismissed. It's like this never happened. Conviction reversed. And that's the case of People versus Lawson. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.